Thank you for the introduction, and I also highly appreciated Dr. Czwertnik's research he did in the previous work of the speakers at the beginning. 6 to 8 minutes, as we were advised to keep our short presentation, is too short. It's very short indeed to present someone's approach in the subject. Therefore, I will make 6 to 8 simple points without detailed explanation, but I'm open to discuss them later. So first, I'm convinced that protection of personal data on the one hand and providing openness of archives on the other hand is not a zero-sum game. Therefore, balancing is not the right expression because it suggests a trade-off model where increasing the realization of one right or demand presupposes the waiving of a competing right or demand. Both rights are fundamental, and we need to find solutions where both can be realized. It's easier to say than realize, but as the main idea. Second, for those for whom access is the main rule, for example, historians, journalists, or open archive institutions, privacy and data protection is the exception, the restricting condition. For those who regard privacy and data protection as the main rule, for example, the data subjects and their families, access is the exception, the restricting factor. We know that there exist archival institutions for whom privacy is sometimes but an excuse for withholding documents which they find politically risky or simply want to be on the safe side. And we also know that there are cases when the archivist provides access to otherwise restricted material to certain trustful researchers under the condition that he or she will not publish the data in a personally identifiable form. One thing is sure, we can never be perfectly neutral and coherent, unfortunately. Third, as we all know, national legislation attempts to restrict access to documents containing personal data for certain defined period. Now, I just heard from Dr. Rehm that in Germany is 10 years after the death of the person. If we don't know whether she is alive or not, it's 100 years from the date of birth. And if we don't know it either, then it's 60 years, as I recorded it correctly. In Hungary, it's 30 years after the death and so on, but there are some deadlines. But these restrictions period are generally too long for the researchers. There is another well-known legal solution, the general closure period, that is usually, not always, 30 years in Europe from the transfer of the documents to the archival institutions. Dr. Czwertnik talked about the Handbook on Access to Archives. This is how it looks like in English edition. There is a French edition too, in which you can find colorful maps where you can check the different general restriction period. These are not the same. The good news is that the Council of Europe realized that it's almost 20 years old, and they want to start a new kind of survey to see the status of implementation of the recommendation on a European policy on access to archives, as we all know. So if you will be receiving surveys, I know we have too many surveys, but in that case, please respond. Fourth, observing the Archives Acts only is not enough in most cases. You are fortunate in Germany or in other countries where you can read everything out from the Archives Act. But in general, I think you need to take the Data Protection Acts, the Freedom of Information Acts, and other acts and regulation in national law into consideration, including international documents like GDPR, and interpret these jointly. Legal coherence is very important here, so that the archivist may not decide arbitrarily in giving or restricting access. Fifth, the archivist may think that she is able to make uniform decisions based on simple rules, as Mr. Doležal emphasized in his introductory speech, that or note that rules should be very simple. But in practice, it's not the case. Many aspects and conditions have to be taken into consideration. Sometimes enacted in legal documents, sometimes not. Sometimes you can extract it from existing laws and regulation. Let me enlist just a few basic ones. The original consent of the data subject, whether she consented to the future public availability of her data. The donor's wish, who is not necessarily the data subject, as included in the deed of gift or deposit agreement. Whether the personal data were created as part of a public function. You touched, several of you were touching this question, but I think the central element is not the public figure as such, but the public activity, and whether the data were created during this kind of fulfilling the public function. And the same is true vice versa when a public figure has private data in the documents. Whether the document or the personal data in the document has already been lawfully published, lawfully, not stolen and published, lawfully published, that means that there is no reason to keep it secret or restricted if it's already out there, but it's difficult to check how it is. Whether the personal data has been made public by the force of law, such as the data of former secret agents in countries of the former Soviet bloc, this is our countries. Whether the document or data have been classified as secret, irrespective of whether it's personal or not, it's very rare because the classifiers generally don't trust the archives, I must say. And whether the anonymized data can be easily combined and de-anonymized or re-identified, that's the same, especially in online environment. So if we want to be honest, law does not solve every problem. The archivist has no time and energy to investigate each and every questionable case. Therefore, we need to use our sense for ethics and imagination. Maybe it doesn't sound well in a legal environment, but in practice, that's reality. 6, and it will be not very long. This conference focuses on problems of access to documents containing personal data. But some of you, including Dr. Barrera, mentioned that there are also questions of rectification or deletion. In my opinion, we can distinguish two types of archives in an informal sense. It's informal, absolutely. Administrative archives and historical archives. You can say that every archive is historical because it's a memory institution. Yes, it's true, but an administrative archive, for example, an archive of a public authority, are responsible for the content of the documents in their custody. And they can even issue certificates about this. While historical archives are not responsible for the truth content of the documents, but they are responsible for the integrity of the document. It means that if a document is full of lies, the historical archive is obliged to preserve it without any correction. And finally, there exist some practical solutions for which you don't need to change the law or the regulation or the code of conduct. Just apply it within your archival institution. And finally, I would like to enlist some simple solutions we try to use in the practice of the Open Society Archive. They may sound trivial, but in practice, it's not always that trivial. First, we need to clarify in-house what we mean as personal data. Not only users, but sometimes archivists themselves. They tend to think that personal data are identifier data only, like names and ID numbers. Or that names are not personal data, that's just names. Or only intimate or sensitive data are personal data. We know that it's not the case. We also need to clarify in-house where are the borderlines of the connection between the identified or identifiable person and the data. Because if every data can be connected with the living person one way or another, then all data in the archive or in the whole world should be regarded as personal. That would lead to absurdity. So we need to define the borderline. Next if we are ready, we need to make an inventory of documents in the archive containing personal data. However, inventorying the whole archive of holding is unrealistic. Therefore, let us segment our holdings into parts that are out of questions regarding the use of personal data, to all documents or press clippings or something like this, and deal only with the rest where there might be such data or document. Now let us label the containers of the remaining part in the paper-based environment. Let's say that's our practice, putting a yellow sticker on the boxes. In the digital environment, adding a digital label to the file. If a researcher wants to have access to these labeled documents, don't give it to him automatically. First, check the content and decide if it contains personal data and if it can be accessed by the researcher. If the physical or digital container does not contain personal data at all, or all personal data are freely accessible, give it to the requester and change the yellow label to green label, or modify the digital label accordingly. This ensures that next time you don't need to evaluate the content of the container, whatever it means, again. But if the physical or digital container does contain personal data that should be restricted, take these documents out from the container or sanitize the document and provide access to the container this way. Change the yellow label to a red label or modify the digital label accordingly, indicating that the container should be checked and certain documents removed or sanitized. I know that these are not legal solutions, but practical ones, but still they can make the archivist's life easy. And I stop here and give the floor back to the moderator.
Thank you very much.